Well, good afternoon, everybody. Bill O'Leary here for our Thirsty Thursday series. Sorry for running a few minutes behind, a couple of technical issues. But anytime you're dealing with technology and the internet, you should come to expect that and just roll with the punches. So again, this is a Thirsty Thursday a talk. It's a series that we do every Thursday at about this time. We call Thirsty Thursday, where we provide information and knowledge concerning estate planning, elder law, and so if you're thirsting for knowledge, you've come to the right place. So that's the whole idea behind this series. Today's topic is going to be, how has the Secure Act affected special needs planning? Okay, so let me first tell you what is the Secure Act. Well, a little over a year ago, a new law went into effect called the Secure Act. And it stands for what's called setting every community up for retirement enhancement. You know, Congress is great at coming up with these acronyms. This new law, really has made sort of significant changes to retirement accounts in several very important ways. And with respect to families with special needs, loved ones should pay close attention, because these changes will certainly have an impact on their estate planning for their special needs loved one. Now, let's go sort of back in time, prior to about a year ago. Under the old way of doing things, the old law, if you named anyone as the beneficiary of your retirement account, whether it's an IRA, 401k, 403b, anything like that, well, the beneficiary could have, under the old way of doing things, chosen to take the distributions from the inherited IRA over his or her lifetime, and then when the beneficiary died, if there was anything left in the account, could then pass on the remaining funds on to future generations. That's what we used to call the stretch option, because basically it was a way for the beneficiary to stretch out the payments over a much longer period of time. And the amount that had to be taken out each year, called the required minimum distributions, and how were they calculated? Well, it was based on that beneficiary's remaining life expectancy. So, as you might imagine, the younger the beneficiary, the smaller the annual distributions that were required, and the longer the inherited money could be stretched out. And what this did was it allowed the money basically to stay in the account, most of it to stay in the account, and grow tax deferred over the beneficiary's remaining life, so that by the time the beneficiary died, there was a whole lot more left in that account for future generations. Well, now we have this new law called the Secure Act. It now requires most beneficiaries of an IRA to withdraw all the money from the IRA that they inherit within 10 years of the account owner's death. So they have to withdraw everything out of the IRA within 10 years. And of course, when they do make a withdrawal, they've got to pay income tax. Okay? So now, again, what that means is that most beneficiaries now are going to be facing a much shorter period during which they have to take the money out of the IRA, which simply means, again, since tax has to be paid, you're going to be bunching the tax into this compressed period, 10 years, instead of maybe over a 20, 30, or 40-year period. And in fact, for some beneficiaries, let's say adult children, they're going to have to be taking this money out during their highest earning years and highest tax years. So what this means is the elimination of the stretch IRA is effectively a tax increase on many Americans. Okay? Now, just by the way, this new law went into effect January 1, 2020, so it applies to anybody who inherits an IRA after January 1 of last year. So let's say an account owner who died after January 1. Now, this new law, the Secure Act, makes exceptions for certain types of IRA beneficiaries. And I'm going to focus on one category, those who are considered disabled according to IRS standards. These people can receive the funds from the IRA in the form of required minimum distributions, what we call RMDs, based on their life expectancy, instead of that much shorter 10-year period. It's really a nice carve out for the special needs community. And so there's a carve out, again, for somebody who is considered disabled, or somebody who's considered chronically ill. Those are two special carve outs, and they often sort of go together. together. Now, what happens if an IRA owner wants to designate as the beneficiary of the IRA a person with a disability, but instead of naming them directly in their own name, they'd rather name a trust as the beneficiary of the IRA? A trust that's the beneficiary of the IRA, okay? Well, can this be done? Well, it certainly can. You know, many individuals with special needs, they receive means tested benefits such as supplemental security income, what we call SSI, and Medicaid. And to receive this sort of supplemental income or Medicaid from any source would, may disqualify the individual. So if the disabled person receives money from some other source, it may kick them off the SSI and the Medicaid rolls. Okay, so in order to preserve those benefits, special needs trusts are very often used to shelter those assets, to protect those assets, or maybe to sort of shelter a continuous stream of income for a person with special needs. Okay, what the trust does is it basically is a way to hold assets and income for a special needs individual, and to be used for their benefit, but also allow them to get the government benefits, principally SSI and Medicaid. And the way it works is the trustee of a special needs trust has the discretion to make distributions towards purchases that would benefit the special needs individual. Now, back to this new tax law called the Secure Act, okay? It's the IRA owner, the owner of the account, can name a special needs trust as the beneficiary, and the trustee can use the required minimum distributions, the RMDs, to pay for the care and support of the person with the special needs. And so the way to set this up is through what's known as what's called a see-through. Basically a special kind of trust that meets the IRS's particular requirements. Okay? So what happens with a see-through trust is that at the death of the IRA account owner, all of the remaining money in the IRA will go into this trust, and it's distributed by the trustee according to certain rules and guidelines. Then the deferred taxes are due when the money is withdrawn from the trust in the form of required minimum distributions. If the person is a beneficiary with special needs, distributions will be paid out over the course of that beneficiary's lifetime. So again, we're able to stretch out the payments, okay? And which is much better than over that much shorter 10-year period, okay? Now, there are two types of these special kinds of what are called see-through trusts. One is what's called a conduit trust, which is simply where the money is distributed out of the trust to the primary beneficiary immediately. The other type is what we call an accumulation trust, which was where the money can be distributed over time. The second variety of see-through trust, called an accumulation trust, is what we use for special needs beneficiaries because it's a way to ensure that the money in the trust will be there to help the special needs individual, but also not kick them off the rolls, preserve those government benefits. So with an accumulation trust, assets or income, sort of like an RMD from a retirement account, but again, the trustee has the option to hold that money inside the trust, to accumulate it inside of the trust, along with whatever other assets or money are in the trust. The accumulation trust will also allow the special needs individual to stretch out the IRA withdrawals again over the lifetime, like I said, much longer than that 10-year rule that applies to most other beneficiaries. A person with special needs now who's inheriting an IRA, they can, again, it's a way to continue to protect their means-tested benefits by having the required distributions from the IRA paid to this special kind of special needs trust. One more quick note about using a trust for a special needs individual. It gets a little tricky. It gets a little tricky where there's more than one beneficiary of the IRA. For example, maybe the special needs individual is one beneficiary, but there's also that person's spouse or siblings or children, let's say. And all of them are beneficiaries of the IRA. Well, how does that affect things? Here's where it gets tricky. The trust, being the beneficiary of the IRA, is only going to sort of be exempt from this new 10-year payout rule, is only going to be allowed to stretch it out If the individual with special needs is the only of the trust for their lifetime, that's critical. So if that trust also permits distributions to these other beneficiaries, like the special needs person's spouse, kids, whatever, qualify, and the IRA will have to be completely withdrawn within 10 years, unless the trust is set up in sort of a certain way where it will split out into a separate sub-trust for the disabled individual immediately upon the death of the IRA account owner. Okay? So really, the safest thing to do is to establish a separate see-through accumulation trust for the special needs relative that you have, and then set up a second trust for all the other heirs. Rather than sort of combine both into one, then you got to sort of walk that, walk that tightrope. It's much easier and cleaner just to create two separate trusts. And if, let's say, you do have a special needs individual in your family, and there's already an existing special needs trust in place, it may be necessary to go fine-tune that in order to comply with this new Secure Act. And of course, it's always a good idea to talk to a good estate attorney like yours truly and the team here at Legacy Planning Law Group. So as I bring this to a close, if you'd like to know more about how the Secure Act has affected special needs planning, and if you'd like to know how maybe we can help, we'd be happy to talk to you. You can book a 15-minute phone call with us. There's no charge for that. Again, as I've said before, just go to the main Facebook page that we have and click the Book Now button. What this phone call does, it gives you a chance to tell us what your concerns are, to see if we can help you, and also to see whether we might be a good fit to continue the conversation in the office. Again, you can book a call through the Facebook page. You can Google us, Legacy Planning Law Group, or you can just call us here at the office at 904-880-5554. So I want to thank you for your time. I hope you've enjoyed this talk on how the Secure Act has affected the special needs planning. I plan on giving another talk about the same time next Thursday as part of the Thirsty Thursday series. Again, same day and time, a little different topic. I try to mix it up for variety. So if you're thirsting for knowledge, you have come to the right place, and we will quench your thirst. So this is Bill O'Leary signing off for now on behalf of the entire team, Team Legacy here, a great team that I have to work with. I want to thank you for spending time with us, and I want you to go make a difference, go make it a great day.